So we'll make a start. Warm welcome to everybody, and I just note that we've got apologies from Councillor Crum and Councillor Webster, and special acknowledgement to Councillor Webster, who's become a grandmother again.
Oh.
So, yeah, either number 17 or number 18, I'm not sure. Either number 17 or 18.
And a special announcement, Councillor Walker is now a grandfather of a bonny 10-pounder.
Well done. Well done to the grandparents. Yay for grandparents all round. Congratulations.
So is he running the Olympics in 2 weeks' time, John?
Family planning pamphlet, 2 pennies.
I think I should send one to mine, actually. Right. Any other apologies that we've... David for lateness, we'll add that. So I'll move those three. Is there a seconder? Councillor Cooper, I'll put that. All those in favour, please say aye. Against, carried. Declarations of interest, we'll get to that. Confirmation of the minutes on the 6th of July. I'm happy to move those. Is there a seconder? Councillor Casey. All those in favour, please say aye. Against, carried. None of those items are relevant to this meeting, so we'll get straight into the business. And just before we start and before I hand over to Catherine, just acknowledging the members who are here. This is an absolutely critical meeting as we enter a very, or potentially quite a challenging time, and I think it's very important that we are clear about who we are and the process, how we interact with the process, and that we are on firm ground to participate. So, again, warm welcome to everyone. Right, Catherine.
Good afternoon. The session you will have seen that's organised that we're leading off with is the legal framework for the decision making in relation to the unitary plan. You'll recall that you were taken through this when you began these information sessions in April, and that was the first bookend of the process. This is intended to close the loop. The material will be familiar to you, but you will now be receiving it in the context of having had the substantive presentations on the 19 topics of particular interest that this committee had identified. I'll run through this. Some of the information has been overtaken by events, as not in terms of the legal framework, but in terms of the milestones that have passed, and I'll just touch on those as we go through. I've got Matthew Allen here with me, who's on secondment into our team to assist with us and who's helped with me prepare for today. You might have appreciated that Karina is now off and has had her baby, a very healthy baby too. So Matthew's helping us out at the current time.
Different babies, don't
The water, yeah.
So the legal framework, first bullet point up there is that this is special legislation for Auckland, but that the content of the plan, notwithstanding the bespoke nature of the legislation, must still comply with the Resource Management Act. As you know, an independent hearings panel has was appointed to hear the submissions and to bring its recommendations to council, and we're on the eve of that phase. Leading on to the next panel, I won't spend any time on this slide. That will be familiar to you, but just that the panel, the key point there is that it's independent. What's not on that slide is the legal effect of the panel delivering its recommendations to council. In that context, the panel will itself cease to exist and will have no further legal existence.
Can I ask a question about that? Yep, you can, Councillor Casey. We might kind of try and break at various bits to answer questions, but yep, question?
I was just on that. If there is an issue with the way we don't know what they're going to say, but if there was an issue with the way the panel did its business and came to a conclusion, is there no way of appealing their process?
We'll come on to the appeal processes, but I think what you're referring to is the ability of people to take appeals on errors of law to the High Court, so that would be the mechanism available.
So anything that's wrong, anybody that sees anything wrong with the panel's process is through legal channels?
That's right.
So they've gone though, they're not liable themselves. They've gone after the due date, they've gone.
That's right.
So it's us.
Yes. Sorry, just returning to this slide. So the importance of points here are the 22 July date, which of course is almost upon us. The second bullet point, what's important, and I wanted to emphasise in the context of that statement here, so the panel must have regard to the matters set out in the transitional provisions legislation. What that means for you is, in fact, it's actually, it must ensure that when it delivers your recommendations, its recommendations to the council, if the council was to accept those recommendations, that council would be complying with all of its obligations under the Resource Management Act. So it's an important provision and highly relevant in the context of the 20 working day decision-making period. Last point there, of course, this is one of the examples of time having overtaken matters, in that the panel did have a legal power to make a request to the Minister for an extension, but of course has not done so and is clearly not going, has no need to do so. This slide here, the short point here was simply to illustrate the elongated engagement process with the community and ability to make submissions under this bespoke legislative process compared with standard plan or plan change processes. Just that the middle line there, council makes a decision on the recommendation reports. This is about obviously the phase that we're about to enter into. Just below that, just an outline of certain appeal rights. So, and I'll come into this in more detail, so I won't touch on this here. We must publicly notify decisions by 19 August, having received the recommendations on 22 July. I think that date's been well publicised and you're all familiar with that. The ability for the council to seek an extension is limited. That is a one-off ability to request for up to 20 working days time frame before it publicly notifies its decisions. And that request to the Minister is entirely at the Minister's discretion as to whether to grant any such request should it be made. Importantly here, there will be much more detail in the reports that come to you in your decision-making role about the legal framework, but the broad points here is that you must consider the panel's report and the reasons for its recommendations, and bearing in mind all of Council's functions under the resource management legislation, particularly Part 2, which sets out the purpose and principles of that Act, and any other relevant planning documents, so national policy statements, etc. This is a high-level overview of what the Council must not consider in taking its decisions. The first point there is any personal interests, financial or non-financial, other than those that are in common with the public. And the second conversation that we'll have with you is just a refresh of the general principles relating to management of conflicts of interest and a discussion around the assistance that might be is available to each of you to work through any matters that you wish to in advance of decision making. In that context, on the discussion of conflicts, we also have two members of the Office of the Auditor General's Office here to give you an outline of the role that office has in relation to the management of certain interests. Must not take into account, must not consider trade competition, the panel's processes, which is the point that was raised, so it's not for us to question that process, and the panel's determination of scope. So the panel determines whether a matter is in or out of scope. And last bullet point, importantly, in which again you'll all be familiar with, is that must not consider any information, so that's evidence or submissions that was not before the panel. Turning now to just an overview of what happens if council rejects a recommendation. We must provide reasons for doing so. Council must agree an alternative solution, and that alternative solution will need to be subjected to a Section 32 analysis, namely a cost-benefit analysis of that alternative. What a rejection of a recommendation does is create a merits appeal opportunity for relevant submitters to appeal to the Environment Court. The last point there is simply that there is an ability to effectively accept a recommendation but make minor changes, but that's less likely to be directly relevant, given that there are other technical opportunities to repair things.
I see you, Councillor Casey, can we just get to the end of this bit and then take that question?
So can the council accept recommendations that are beyond the scope of submissions? The answer is yes, but only in circumstances where the panel recommends that we do so. The legislation expressly enables the panel to do so. The language in the Act is that the panel is not limited to making recommendations only within the scope of the submissions made on the proposed plan. But what the panel must do when it gives its report to us is identify which of, if any, recommendations that it is making to us it considers are beyond the scope of submissions.
Can we just pause there for a second, Catherine, because I think now we go on to appeals. So, Councillor Casey?
My question relates to how the public will know what we're thinking, because if we have a confidential briefing the following week after so the independent hearings panel's recommendations are made public, then we go behind closed doors to start discussing it. Presumably the public don't get to know what we're thinking till August. Because if we have to do all that Section 32 stuff, that all has to start back then, not in August, right? So I'm not clear about how transparent that is.
So
I think
can we wait? I think how about we address that when we get into the process, into John's presentation. All yours. So we are going to go through the...
What you're talking about is not really related to the legal framework. It's about the process that you have decided to follow, which is an open and transparent process. So there will be no discussions of the recommendations in private. Next week is just a very high-level briefing, and the meetings of the 10th, 11th, 12th, 15th, 16th, 17th are where you will debate whether or not you wish to accept or reject a recommendation of the panel. And if you want to reject something, then we will have to debate the costs and benefits of alternative provisions in those public meetings.
So are you saying there's enough time between the 10th, 11th and 12th to get the Section 32 work done in time for the 19th? Is that when it happens?
Well, we will
earlier?
have, if this council wishes to reject any of the recommendations, staff will have to draw up alternative provisions instead, and we will have to do the cost-benefit analysis, because all of that has to be part of our notification of our decision on the 19th of August. So yes, we will have to do that.
So, and there is enough time between the 10th and the 19th to do that?
And I think this is the hard part, Councillor Casey, until we see it on the 27th and we have a sense of the scale and extent of the recommendations, and then we have an idea of the scale and extent of any areas of concern, it's very hard to kind of prejudge how big or small the Section 32 analysis would be there may be none, there may be quite a lot, and the bottom line is we'll need to make the work fit the time. Okay. Councillor Quacks.
Yeah, thank you. Couple of questions, Catherine, before we move on to the next section. If a person, well, I guess a decision maker, this is about conflicts of interest. So if a decision maker or a person or a decision maker, which is councillors, I guess, or a body that a decision maker has is a member of or is an officer of, has made a submission to any part of the unitary plan, what is their status when it comes to a conflict of interest?
So can we cover that in the conflict of interest portion? We've got a whole section of this on conflict of interest, Councillor Quacks, and it will run us through all of this.
Okay,
So
we'll keep
hold
that
that
in mind.
question, we'll
Okay.
go into it.
And I wonder if you'd just describe for me, please, what happens if a council rejects a recommendation, provide an alternative solution, i.e. prepare alternative provisions that is within the scope of the submissions of the proposed Auckland unitary plan. Just give me some guidance around what is meant by that so that I understand that fully.
Sorry, I just wanted to...
What I want to know is, when we talk about within the scope of the submissions, what is meant by that?
That is the submissions that were before the panel. So the detailed
So those are the submissions that are on the website and that the panel have heard? Yep.
That's right.
Okay. All right, I understand that. Yep. That's what I...
All right, thanks, Catherine. Oh, hang on a sec, Councillor Chloe.
As just regards the our ability, if we wish to ask for an extension, presumably that's direct with the Minister of Conservation and Environment, is it?
Let's not do that.
It's with the Minister for the Environment, so
So let's just say we are 3 or 4 days through our discussion and we're kind of running way behind, and it might be the equivalent of filibustering going on. When do we make that decision to ask for an extension, and can you get an answer within a day? Because that's reality. It could be, it's going to be not on the first day we're going to decide to go for an extension, it'll be after 3 or 4 days because we're getting nowhere, or very slowly. We would then need to apply really quickly and effectively get an overnight decision. Is that how it will happen?
Well, there's some practical aspects in that are beyond purely legal, but in a pragmatic sense, the bottom line is that you must apply before the original deadline expires.
Yep.
It will be a judgment call if it was necessary, and would also, and almost certainly would require agreement of the committee to do so.
Sorry, I do understand all that. It was more just, are we confident if we go that way, and I'm not proposing we go that way, but are we confident that we would get a quick turnaround on an answer and not end up after the 19th?
We can't really speak for third parties, so we can't speak for the Minister.
So let's start it with good intention and no filibustering and focus on the job. Okay, thanks, Catherine.
So, appeal rights. A submitter, so a person who's made a submission to the panel can appeal to the Environment Court where we reject a recommendation. So that's a merits appeal in that circumstance. I think you're all very clear that where we accept a recommendation, that merits appeal does not exist. Where we accept a recommendation that the panel has identified as being out of scope of submissions, that widens the gate as to who may have a merits appeal. And as outlined in the second bullet point, a person who considers that they will be unduly prejudiced, and that is not a submitter, it's a much wider class of people than submitters, can appeal to the Environment Court in that limited circumstance, even though they have not been a submitter. There are separate provisions relating to decisions relating to designations and heritage orders, and those separate provisions apply ultimately because council is not the final decision maker in relation to those matters. You receive the panel's recommendations, you yourselves make recommendations to the relevant requiring authority or in relation to the heritage orders, and other persons are decision makers.
Can there be a group action?
Class actions in New Zealand are still in a testing ground, so I can't give a conclusion view on that.
Okay, Councillor Casey?
If we make a decision to reject something and a submitter doesn't like it, is that grounds for appeal? What are the grounds for appeal?
If we accept a recommendation that the panel makes to us, and that becomes the decision, a person who does not like that decision will not have a merits appeal unless it was out of scope of the original submissions. So just pacing through that, if we accept that the norm would be that recommendations are within the scope of submissions to the panel, if that's the only universe that we're faced with on 22nd of July, and we accept the panel's recommendations, a person does not have a merits appeal to the Environment Court. What they do have is a right of appeal on an error of law to the High Court, and they would have an ability potentially to bring a judicial review action challenging council's decision.
That judicial review is against the council?
Yes.
Okay. Councillor Darby?
Thanks, Chair. Just on that appeal, so there's the right to appeal through lodging an appeal, but then there's also a right through being a Section 274 party, which is sort of sits under an appeal and attached to an appeal. Would you just, for those of us here who don't know the difference and the position of each and the influence of each position, and also maybe touch on the question of costs. Appeals cost money, but also council in defending its plan might go to secure costs against an appellant. It might go for costs at the conclusion of the appeal. I think we need to discuss that part as of an appeal too. We're talking about appeals. That is the wider context of appeals.
I'm just getting some advice from my left, Councillor Darby. I think we can touch on that, but remembering that some of this may then be legal advice that will be required to take should we go down that track. So we'll just need to be a bit cautious. Did you want to respond, Penny, or let Catherine respond?
Just a couple of very brief comments. It's in the Environment Court's hands who it permits to join as a Section 274 party. But that's a fairly liberal approach, as I understand it, and Matthew will be able to correct me if I'm wrong, in relation to that, the breadth of the approach.
Submitters and those who have an interest greater than the public generally will typically be able to join as Section 274 parties. And I think your other question related to costs, do you want to address that? The only comment I'd make on the costs front is that generally in the Environment Court on plan appeals, parties, the council wouldn't seek costs or get costs typically. It's unusual. Is my only comment on that.
So I think why I raise this, Madam Chair, is that's my understanding as well, and I think a lot of people might be concerned about the mounting costs that might come their way if they continue to challenge through appeal. And my understanding is the Environment Court is very lenient unless it is vexatious, and that's in a different category. Is that correct?
That's right. I mean, as I said, if you look at the court's practice note on costs, for instance, in the case of plan change appeals, district plan appeals, they typically won't award costs against litigants.
Thank you.
It's unusual.
Useful. Thanks, Councillor Darby. I understand the line of questioning, and I think that's useful for people to know. Okay, shall we? Oh, Councillor Brewer?
Oh, thank you. Catherine, the Independent Hearings Panel's website makes clear on their homepage that the council, bracket, governing body, will consider the panel's recommendations and make decisions on whether to accept in part or reject recommendations. Are you envisaging that between the 10th to the 18th of August, it will be, as the IHP has stipulated, the governing body that makes those decisions around accepting or rejecting recommendations? And if not, why not?
Through the chair, it's only the governing body that is delegated to make a decision on the Independent Hearings Panel. The Auckland Development Committee can receive the recommendations of the panel and discuss them and then make a recommendation to the governing body, but it has always been the process that it will be the governing body of Auckland Council that makes the final decisions to accept, reject or accept in part the recommendations of the panel.
So will we be meeting, with that in mind, I presume we'll be meeting those consecutive meetings from the 10th to 18th of August as the governing body?
At the moment, the discussion has been around the ADC meeting as a committee and then making a recommendation, and the governing body being convened on a regular basis through that time to accept the recommendations of the ADC committee. And at the moment, I guess the size, you know, we're kind of second guessing what we're going to be given, the size and complexity of this, and we need to find a way to make this work.
Well, just on that, Madam Chair, it's certainly, reading the IHP's interpretation of it, is that the governing body will be doing that work, and I suspect that members of the public would be thinking that the governing body would be making those decisions, not merely ratifying it at the end or at the end of each section.
Fair enough. Councillor Quacks.
Madam Chair, if I heard you correctly, what you're describing is a much more protracted process than it would otherwise be. You're almost talking about a two-tier process where it goes to the ADC and then goes on to the governing body, rather than going straight to the governing body, which is the expectation, it seems, of the IHP.
Yep. Well, Councillor Quacks, you'll remember that that was the way we worked through the draft, and it worked very well, and it allowed the process to proceed smoothly.
Unfortunately, Madam Chair, we've only got 20 working days on this right now. That's the difference.
I think we did the draft in
5 days.
in 5 days. So let's just have a crack at a good process. Okay, back to you.
The draft. This is the final.
Yeah, big difference.
Just in relation to what rights of appeal or challenge exist in the High Court context,
I'm going to understand that.
as I've noted, there's an ability of submitters to appeal to the High Court on questions of law only, and there is the ability to seek judicial review of decisions where a submitter had a merits appeal. The standard Environment Court process would require them to exercise the merits appeal before they took any judicial review action. In terms of what would it mean for council if there
Hang on a sec, Catherine.
Just
Councillor
can you
Casey?
unpack that a little bit? Just give me an example of a point of law. Or give me an example. You must be thinking about this. What can people do to us? Can you just give me some examples?
You'll appreciate, councillor, that we're in a public meeting.
But adequately consider.
I'll take my cue from the chair as to whether I should answer.
I think maybe just something a little bit,
Not adequately considered.
keep it
Hypothetical.
reasonably theoretical if you're comfortable doing that, Catherine. sorry, let's just get clear. So, councillor Casey, what you're asking is
Just some
kind of a
examples of
theoretical.
points of law. I'm not a lawyer, so I
So,
don't know
what is a
people can do.
point of, what's a good example of a
Yeah.
point of law? I think that's probably
What's a
safe
common
ground.
point of law that would be taken to a judicial review?
Judge was taking it back.
So the panel is required when it delivers its recommendations to us to ensure that all the provisions of the Resource Management Act are complied with. If it had applied the wrong test and therefore drawn the wrong conclusion in that context, that might be an error of law that could be open to challenge through this process.
Right. So if we're looking to reject something, we can't use that same kind of method, look for points of law that could be challenged. Are we doing that as well as a council? Are we checking on their points of law?
I wouldn't have envisaged that we were reviewing the
Yeah.
panel's decision for that purpose.
So I think I can see what councillor Casey's asking for. So there needs to be some sort of presumption or some feeling of security about the panel process and what's handed to us. The points of law or the disagreement around points of law are purely then in the hands of submitters and their lawyers to endeavour to uncover. We have to have some sort of presumption of
That's
good
right.
process.
Council in the 20 working days is entitled to assume and rely on the panel's work in relation to delivering us something that complies with all of the Resource Management Act requirements. So we can't be expected to second guess all of that. So we're entitled to assume as a baseline that that's satisfied. Even if somebody in the public raised a question about that, that would not be of itself, because people can question everything, of course, a sufficient basis for us to conclude that we should agree and put our process on hold. That we're not given an ability to do that in the 20 working days.
Shall we carry on? Some of this might become clearer, but it's good to make sure
So
everyone
just one point. So
understands.
the appeal period runs from the time council makes decisions. So it is appeal rights for and for persons other than council, effectively.
For how long after the 19th of August?
It's the standard 20 working days, isn't it, for the appeal period? Yeah.
Is that the same for judicial review?
No, judicial review, there's no specific time frame, but in judicial review, the courts have a discretion whether or not to grant relief. So if somebody sat on their hands for a long period of time and did nothing, it would make it more unlikely that the court would exercise its discretion to grant relief, even if the merits of the claim had been, not the merits of the procedural issues had been determined in favour of the applicant for judicial review.
I should just add, as Catherine noted earlier, there are separate rights of appeal for designations, and there's a different time period there, 30 working days for designation appeals, but otherwise 20 working days.
What does it mean if there are appeals? Obviously, this affects the ability of the plan to become fully operative. So it can't be fully operative until appeals are resolved, any appeals are resolved. And particularly those parts that are the subject matter of the appeal are the specific parts that would not be operative. What that would mean is that legacy plans would remain in effect. For consent applicants, what that means is that they would have to apply under both the legacy plan provisions for consents and the unitary plan. So that's a regulatory impact on applicants and also on council as the entity that has to process and decide such applications.
Oh, councillor Cashman?
Thank you, Madam Chair. Catherine, so conversely then, parts that aren't appealed are then adopted as the new law for the council's processes?
That's right, so the
And the legacy ones fall away?
That's right.
All right.
Any other questions on that?
Thank you. If any, Councillor David?
Just interlinked, just following Councillor Cashmore's question, which is an interesting one about when something's adopted and the others fall away, but the old rule book was written quite differently, and it was, I'm fascinated by the interlinking of things whereby you have to read that, say, whole section in full and apply it, yet there's a new plan in place that where there's an adoption of a rule that affects how you read what's left over, if you know what I mean. How is that dealt with?
I think it's...
Do you get
it's
the drift?
complex. There's a bit of crystal ball gazing involved at this stage until you've seen the appeals, how they're framed, how broad they are, which parts of the plan are potentially impugned. So it's a little bit difficult to unpick in the abstract, but Catherine's right, there's a provision in the RMA which says that once rules are no longer subject to appeal, they're deemed to be operative, and the previous legacy provisions, the equivalents, fall away. Perhaps easier said than done, and I agree it can be difficult to unpick, and that's going to be a work stream in its own right, trying to identify which parts of the plan can be regarded as operative as we move forward, and which parts still remain
Okay, thank you.
post.
I think that might get clearer to us as we proceed. Penny?
And I think the comment that needs to be made with this is that when we talk about legacy plans might still be applying, we need to remember there are 7 legacy district plans. So it's not just a matter of looking at one legacy plan to understand the difference between the two. It will mean the resource consenting staff need to maintain 7 legacy plan provisions for those provisions that are appealed. So it does become a very complicated management process going forward.
Okay. Councillor Casey, you had a question?
2 questions from earlier on, sorry to go back, but in an early slide it said we've got to take cognisance of the RMA, particularly Part 2, and any other planning documents. What does that mean?
National policy statement.
There are a range of planning instruments which could be relevant. The New Zealand Coastal Policy Statement, for instance, is a good example. The plan needs to give effect to that instrument. The Auckland plan, of course, is something that needs to be had regard to as well. So there are a number of instruments. It's probably worth getting with the narrow scope of the exercise if you're accepting. If your inclination is to accept a recommendation, then you need to know more, because the legislation requires the panel, the independent hearing panel, to certify that it's gone through all this for you. It's really when you're considering rejecting a recommendation that you're really having to
Then you
drill
look
down.
at all the planning documents to see where you can find a reason to reject. That doesn't mean, oh, that's good. I had another one, just one sec. Sorry, I should have asked it at the time. I might ask you to ask it when I remember.
If anything else comes up, please ask it. That's absolutely fine. Right, next.
Oh, I've remembered it.
Oh,
Sorry.
hang on, Councillor Casey.
Right, here's a recommendation from the IHP, and I like the first part of it, but not the second part. Are we able to do a bit of juggling? So this is one sentence, one recommendation.
Yes. Yeah, I think you may, again, we're sort of looking at things in the abstract here, and we don't know what we're going to be dealing with, but potentially you're then having to reject, potentially, but in rejecting, you can accept parts of the original recommendation, and this then has an effect on the scope of appeal rights. It's probably a little complicated, but your appeal can be limited to the difference between the recommendation from the panel and what you're taking forward as the council. Hopefully that makes some sense.
No, I don't understand.
But you'd probably be having to reject if there's a recommendation and you part part accept it, part reject it. It doesn't actually strictly provide for that, but you'd probably reject and maybe define the extent to which you're rejecting, so as to make it clear what parts of the panel's recommendation remained in play.
So then when
Probably
it
it's
says...
difficult to look at in the abstract. I think it'll be easier, hopefully, once you've got actual...
Councillor Casey, can we, I think I totally understand the question you're asking. I do think we might have to wait though till we see the form of the recommendations. We are asking our advisors to do some crystal ball gazing that's kind of really hard to do. Well, you know, I think we've got the 27th for the content briefing, and then we've got the ability to, we've all, you know, many councillors have raised questions, they've put them in writing, they've made it clear to the staff that these are the issues that they're going to want to drill into. I think that's the time then to sit and get that information and have a look, and you know, then we enter the debate. But I don't know if we can answer your question now.
Finding an alternative solution if we don't like a recommendation. So if we half like it, we only need half a solution.
And the answer is, once we see the form of the recommendations, we'll know if that's possible or not. So let's work on that. Happy to, you know, if you want to keep talking to Catherine about that, that's fine.
It might...
Okay. Conflicts.
So what I've got here for you is just an outline of what we're going to be covering today. It's a refresh of highlights from some of the Office of the Auditor General guidance with which you are already familiar, relating those at a very high level to the unitary plan context, and then having an outline of assistance available to you both through Council itself and the separate conversation that you'll have with the Office of the Auditor General about how they may be able to provide further guidance and assistance in this process. So why are we doing it now? It's just good governance, but particularly as we're coming into a series of decisions that are very important for Auckland, we thought you may find it helpful to run through these. The context in which we're coming to this is that governing body and committees routinely make regulatory decisions under various acts, including the Resource Management Act, and always require you to consider whether you've got any financial or non-financial interest to declare, and it's a standing item of our agendas for that to happen. The unitary plan decisions are similar to plan change or operative plan review decisions, but I wanted to emphasise in this context, this is one plan for Auckland that is vertically integrated. So when you've been making decisions previously on other plans or plan changes, you've been looking at things in a slice or an element of the planning framework that applies. Here you will have before you one set of rules that will apply from the regional policy statement down to the district planning rules, and that provides a different context in which it will be important for you to understand and consider any relevant conflicts. Our last point there, legal services and the Office of the Auditor General can provide relevant assistance in addition to the material that's available to you electronically. The first point, and it is an really important point to raise here, is that conflicts of interest are natural and unavoidable. The quote there, New Zealand, we are a small country. Conflicts of interest in our working lives are natural and unavoidable. The existence of a conflict does not necessarily mean that someone has done something wrong and it need not cause problems. And that's really important to bear in mind. Just because somebody has a conflict that they have to manage, it's not a question of fault, it's something that naturally arises. The key is identifying and managing them. Here we've got a quote from an inquiry the Office of the Auditor General did in relation to matters in Ashburton. And I just wanted to emphasise here, the reason I pulled this out for you is that conflicts of interest here, and many commentators on conflicts will make these points, as do numerous judicial decisions, that conflicts of interest are more likely to be grey than black and white. And the point there that where an elected member has a potential conflict of interest, they need to weigh a complex set of competing concerns. Unless there is a clear financial interest, in the end, each member will need to make their own decision on whether it's appropriate for them to take part or to stand aside. Here, just guidance on careful management. Not a simple set of rules that I can pick up and give you and tell you how to do it. It's all very context and very personalised. The last bullet point there, in difficult situations, it may be necessary to seek professional advice and or consult other public sources of guidance. And just the point being made there is all of this assistance is available to each of you. This quotation from the Office of the Auditor General's Good Practice Guide, and you will have heard this repeated often in this chamber, is that it's always safer to err on the side of caution in these matters. I made the comment there that transparency can be enhanced by visible management of conflicts, and that, of course, underpins why you have the standing agenda item where conflicts interest can be identified and declared and listed transparently in Council's minutes. This example here, example 1, where somebody's made previous comments on a proposed decision. The Good Practice Guide says you could create a legal risk for the decision that the local authority is making if you participate in the consideration of the matter, and if you have made statements that suggest your mind is made up about the particular matter before having heard all views, that your position is so fixed that you are unwilling to fairly consider the views of others, or that you are not prepared to be persuaded by further evidence or argument, or that you refuse to read or listen to reports or submissions presented to the authority. The point I wanted to make here that you've got highlighted in the box is that there is a clear line between having a view that you keep to yourself, having a view that you articulate, commenting on policy issues in a political context. But keeping an open mind is the key. There is nothing problematic in articulating or having a view. The main thing is to have that open mind and be able to show, if anyone later makes an allegation that you did not have an open mind, that you came to the decision making prepared to take into account the information before you. And recommending a cautious approach consistent with the advice that Stephen and I have given you around taking a cautious approach to commenting on the decisions before you in this important phase. Example 2, where a member has made a personal submission. The Good Practice Guide indicates that you could create a legal risk if you participate in the authority's consideration of a matter where you've made a formal submission to the authority in your personal capacity to support or oppose a particular proposal as part of a public submissions process. And the second point, I'm just emphasising there that in our own code of conduct, it says that a member must not deliberate in a public consultation process where that member's made a personal submission. So in short, no discretion under our code to participate, notwithstanding that it's normally an individual's decision whether or not to do so. The second part in that box is important, in that the requirement to stand aside is confined to only those parts of the decision that are directly relevant to what may have been the subject of a personal submission. So it's a very proportionate response. Is important. You don't need to throw your hands up and think that you can't partake in all of the decision necessarily, but again, very context specific. Example 3, you may have a close relationship or association with another organisation, entity or person that has made a submission or has made comments on the proposed decision. I'll let you just reading through the guide there. The things to highlight there are, again, increased legal risk if you participate in a consideration of a matter before this authority involving or affecting a club or similar organisation that you're involved with. But this is limited to if you're an executive officer or trustee or otherwise strongly publicly identified with the club, or the matter specifically and significantly involves or affects the club. On the other hand, the possibility of a decision being challenged under this example is likely to be very low if you're just a passive or ordinary member of the club and the organisation is relatively large, or the matter affects the club only indirectly. Similarly, legal risks are likely to be low if you participate and have only had a past involvement with the club, or merely have friends who are involved with the club. The point in the box there is that based on the 2015 annual interest declarations, there are a number of entities that have been listed as identified with different members that have made submissions on the unitary plan. What that means is that in those circumstances we're happy to work with you one-on-one to work out where in this cascaded list of legal risk it might sit, which is very dependent on the level of involvement with the relevant entity. Fourth example is where you may have a close relationship or association with another organisation, entity or person that may be affected by the proposed decision. So the distinction between this example and the previous one is that these other entities may have made a submission on the proposed decision. Here it's that they might be affected by the proposed decision. The commentary here, for example, if you've been appointed as a representative on the governing body of a council-controlled organisation or another body, that role will not usually prevent you from participating in relevant matters. However, you could create legal risks if your participation in that decision raises a conflict between your duty as a member of the local authority and any duty to act in the interests of the other organisation. Again, the comment here that from the Office of the Auditor General that these situations are not clear-cut and will often require careful consideration and specific legal advice. And then the final point there as to whether involvement with any other organisation might raise a risk of predetermination. Again, a matter to be assessed, and particularly if that other organisation has made a formal submission to the authority as part of a public submission process. This is just continuing that same example. The point I wanted to draw from here is in this kind of circumstance, you need to consider how those with whom you have a close relationship or are associated may be affected by unitary plan decisions. And again, it's important to emphasise that individualised assistance is available because it is slightly complex to work through these things. The purpose of this slide is just to, in a very brief way, and I'm not proposing to spend a lot of time on this, just to outline for you a summary of the approach in this 2014 inquiry, which was a decision to designate land for a bridge in circumstances where the council was accepting independent commissioner's recommendation. Different councillors had different interests, one through owning property adjacent to the designated area, so outside the area proposed to be designated. One councillor had a brother who owned land within the designated area, and one had a sister-in-law owning land within that designated area. Different councillors took a different approach to how to manage those particular interests. The first bullet point there in relation to Council Urquhart's land is important because what it demonstrates there is that the office said that the effect was not sufficiently certain or significant enough to constitute a financial interest that would trigger the application of the rule against participation. That's designed to demonstrate to you that outcomes that are too remote, are in some way come off the table. So it's that on the spectrum of, outcomes that are quite remote through those that are quite certain is the spectrum, and working out where a particular interest sits is important. In relation to the non-financial interests, which were where the two councillors had family members with land within the designated area, one participated in the decision and one did not. The office noted that there were different approaches, but that all approaches were reasonable. In relation to the Environment Canterbury inquiry, which was around the allocation of costs for managing water resources, in the circumstances where 4 councillors held consents in their own name or in the name of companies of which they were shareholders, with a potential financial benefit from the decision, but only in a relatively small way. In summary, the Office of the Auditor General found that 4 councillors breached the Act by participating, and that reference to that is the Members' Interest Act, which Sarah and Jonathan from the Office of the Auditor General will be talking to you about, and by participating in a decision in which they had a financial interest. But weighing matters, the office decided that prosecution was not warranted in the circumstances. That third to last bullet point from the bottom of the page, the issue of whether a councillor's pecuniary interest or financial interest is an interest in common with the public will always depend on the circumstances of the case and is always a question of degree. So again, a consistent theme through this, that it's context, its circumstances, and which is really what we're emphasising here to you, is that it's personalised advice to individuals required. And the final point there, just noting that the office disagreed with legal advice that one of the councillors had obtained, that because it was a policy decision, they could participate. So the office disagreed with that view. Just a couple of slides before I hand over to the Office of the Auditor General, and then it might be helpful if we collectively take decisions at the end of that.
Actually, we might just change that a little bit, Catherine. We might just take any questions on this now and then take a 2-minute break and then do OAG.
All right. So just general comments. Although dependent on the facts of your particular scenario, if you share a financial interest with a large group of the public, then it's unlikely to be considered a financial conflict of interest and relevant to the unitary plan decision making. Although dependent on the facts of any particular scenario, you can be related or associated with another person, entity or organisation who might be affected by the decision and still participate in this decision, but this requires careful assessment of the situation. What's the overarching key principle that we'd recommend you bear in mind is, would a fair-minded observer reasonably think that the decision maker might not bring an impartial mind to the relevant unitary plan decision? That is, that the decision maker might unfairly regard with favour or disfavour the IHP's recommendation or related submissions and evidence due to his or her non-financial or financial interest.
Thank you, Catherine. Mr. Mayor, you had a question?
Yeah, just so I want to start at the other side of the coin. A fairly long and exhaustive and necessary description of the fact that we're going to be sitting as judges in a process, and that it's very legal, and so we need to come at it, as the court says, with clean hands. But what I want to know is, what are the consequences? Why are we going through, this is asking a question that some of us know the answer to, but why are we going through this process? What is the risk here to the decision making that we're going to make in terms of the final plan if someone participates and they have an undeclared conflict of interest?
If I could refer you to page 15 of the agenda. This list is a table from an Office of the Auditor General report that deals with partly this question of consequences, which is not the full answer to why does it matter. While I'm getting you to turn to that, just make the general point that the trust and confidence of Aucklanders in council is related to the probity in decision making, and fundamentally what managing conflicts of interest is about ensuring fairness, and that fairness demonstrated and visible contributes to the trust and confidence of Aucklanders in this scenario in relation to council decision making. Looking at page 15 there, you'll see that down the left-hand side, there's various scenarios that are identified as either being a financial or non-financial conflict, or a conflict of roles, or an issue of predetermination. The middle column showing what the relevant law is, and you'll see that most of it is common law, apart from the Local Authorities Members' Interests Act, and legal risks, specifically for the member, arise in relation to the management of financial interests, with a potential consequence of a conviction under the Members' Interests Act if the Auditor General decided that prosecution was warranted in the circumstances and the prosecution succeeded. That leads to automatic loss of office and potential fine. The risk for the organisation, for the entity that council is the risk of judicial review and having a decision potentially set aside by the courts in this process is the consequence for the organisation. So you see, tracking down through that column on the legal risks, that it really indicates the difference of consequence for members and for the organisation.
Would it be set aside in part or in full if the declaration was relating only to one specific part of the plan?
I think the court would again take a very proportionate approach. Council would certainly maintain the position that if anything should be set aside, it should only be that relevant part of the decision making that related to that particular interest.
Thank you. Good question. Councillor Cashmore.
Councillor, could you please just redefine for me that close relationship or association, and perhaps illustrate it with an example?
Sorry, Councillor, I was...
Oh, sorry. Just could you redefine for us, please, the definition of a close relationship or association actually means in reality, what it might look like?
In the examples that you've seen there, it can be family members.
Yep.
It could be a close relationship with an organisation, maybe because you're a trustee of a trust. It may be because you're a beneficiary, and particularly at higher interest if you were the sole beneficiary of a trust, through a shareholding in a company or directorship of a company. And also through, I'm not giving you an exhaustive list, there are a range of ways in which that interest could arise, through organisations of which an elected member is a member, and where, in this context, where that organisation may have made a submission.
Well, I guess my question is context, Madam Chair. Where does the line draw? For instance, if someone had shares in a property development company that was publicly listed, would that put you in conflict? A whole lot of provisions around potentials in the unitary plan on that, or is that too distant?
Yeah, so I'm reluctant to get drawn into specific examples, but at a very high level, and it depends on knowing all of the relevant facts. But the interest in common with the public, in the sense of those who are shareholders in a publicly listed company, is likely to be a significant number of people. So again, very context specific as to whether that would be a relevant interest, and you would need to look at, would that listed company have anything that may be affected by the unitary plan decision making. So there is care needed, but it's not an absolute that just because you're a shareholder in a listed company there's an interest. But all these things need to be worked through.
Thank you.
And that's a good segue into the fact that Catherine and the team will be available to meet with every member of the committee, and I would presume every member of the committee would meet the team to go through their own personal declarations and any possible conflicts. And I've gone through that myself, and it's a very, very useful process to go through.
Depends on how
Councillor Ross-Clow.
It's just that on that page 15, the last one on predetermination, and I totally understand what that's about, but it says there how they're going to vote before they've listened fairly to all the arguments. In many ways, what's coming back from the entry plan is not a set of arguments, is we're getting a determination. Where are the arguments going to come from? Is that just going to be staff giving us the counter-arguments? Because it is a determination.
So what the panel will be sending through to the council is recommendation reports, and their recommendation reports need to give the reasons why they are recommending changes to the plans. So they will be setting out, if they do choose to change aspects of the plan, they need to give their reasons. They also need to give a Section 32 analysis, which is that cost-benefit analysis of the impact of the changes they're suggesting. And then they will give us a clean version of their version of the plan, so showing how their recommended changes change the plan. But it's not just a recommendation, they have to give us the reasons for those changes.
Thank you.
Can I just make sure I've got that? So the staff are bringing us recommendations for change?
No, the panel
you're
panel
talking about
will be
the panel, not the staff.
delivering recommendations
With their reasons for
with their
change.
reasons and the Section 32 analysis for their reasons for changing.
So then it's over to us.
And then you guys, the governing body and the committee will consider the recommendations and those reasons and decide whether they agree with the reasons given for the changes or not.
Okay. I've got a couple of questions that might belong here and might not. But while you were going through all those case studies, I kept thinking about Councillor Debbie Hewitt of the Ruitaniwha Dam, who the Auditor General said could make a decision even though she did have a financial interest in the outcome. So maybe I should save that for the Auditor General. Because it's a very odd decision, that one. I've got three questions.
Don't make odd decisions.
3 questions, and it might not be appropriate here, but I keep thinking in 30 days we're making decisions on the unitary plan, in 80 days a new council will be elected. And in that interregnum period, there's going to be an awful lot of people speaking out. And it's about that in terms of these, these guidelines. You're talking about the decision makers. I'm interested in whether these guidelines affect other members of Auckland Council in terms of other elected members, not us. That's the first part of that question. I can give you the rest if you like.
Should we do them one at a time, Councillor
Okay.
Casey, because that's a good question.
Whether or not to declare whether or not you have an interest, should declare it, and what you might do about that, is only relevant when you're in the decision-making seat. So, for other parts of council that are not decision makers, they will not be required to assess or declare conflicts of interest because they are not decision makers.
Okay, what about Bernard writes a headline about one of the recommendations and people respond. We can't respond, the decision makers can't respond. Can other members of Auckland Council respond?
I guess
You're talking about local board members.
Yes, I am.
And the reality is there's no way that we can control everything that happens in this process. I guess, wouldn't it be great if we could actually enter this process kind of in a dignified way and step through the recommendations and work it through and be supported by all other arms of council to do that. I don't know if that's achievable, but we need to stay separate from that chaos and sit as decision makers, exactly as Len has said. Basically, we're a panel of judges who need to be required to focus on what's in front of us and not be diverted by the external issues.
Well, just along the same lines, again, it's the election period as well as being the unitary plan period. If a candidate, that would be everyone in this room who is standing again, is at a public meeting and all candidates on the platform are asked a question about the unitary plan, does that mean that the only person who can't answer it is the decision maker and that everybody else can have a good go at them?
Well, councillor, that's probably a good reason then to have the decision made by and completed by the 19th of August.
It also means that the current mayor can't speak, but every other wannabe mayor can. Is that right?
Well, there's no stopping any other wannabe mayors from speaking.
Yeah. Okay, that was my second one was, I remember when we had the quite fraught meeting about the withdrawal of the upzoning plans, the maps, sorry. Yeah. And I remember some legal advice then that almost you were damned if you did and damned if you didn't. Will the effect, is there any effect of that decision made on that day, which was quite a close vote, can that come back and bite any one of the parties on the bum, either the nays or the yeas? Sorry about the word bum, I couldn't think of one.
I do want to give some confidence to you around that. It's not uncommon in a long-running process to have parts of the process where there's very heated and spirited debate. And what happened in this committee was decisions about what council's position would be before the panel. In that context, the panel is taking into account council's position and the position of other submitters and making a recommendation back to us. What's important is that there's a continuing open mind to receive what the panel has to say to council and its recommendations and its reasons. That would only be problematic in the sense of anyone was indicating that they would refuse to look or consider any recommendations that were the same subject matter. And my understanding is that everyone here will be bringing an open mind to that discussion in the context of quite a distinct phase of considering the panel's recommendations where it has heard from everybody.
And that kind of segues into my last, which I think you've actually answered. When you're looking at things you may have said in the past about a certain issue, someone could basically go back for years to find out your position on a thing. But for the last few months, all of us have been told not to speak out because we have to go open-minded into the final decision-making. So if somebody does come with a big litany of stuff you've said about something, that can be dismissed as, yeah, that was then, and now I'm entering the new phase with an open mind.
The new you.
That's the answer. The new me.
Yeah, right.
That's it, right.
That's it. I think that's a good summary of where we're at. Other questions before we just take a
Madam Chair, can I
2-minute
just
break?
very quickly pick up on the point about local boards? I'm not sure whether we got a direct or clear enough answer on that. I think that, clearly the local boards aren't sitting around the table, but they have been as close to the action as anyone. So it would be helpful to just be clearer around their responsibility, either moral or legal, in terms of maintaining some degree of decorum during the course of that 11 days.
Perhaps I could comment that the early June memorandum that was circulated to all members of this committee and local board chairs, in terms of which included the local board role, acknowledged expressly that they're not subject to the same restrictions officially as decision makers in waiting as other people around this table, but did ask them, this was from Stephen, to respect the position that elected members are in their decision making role.
And that's the relationship that councillors have with their local boards, which in most cases is a pretty good one. Okay, right, I think that's the end of your part of the presentation. We'll just take a quick 2-minute break and then we'll swap over to OAG. start. Come on, everyone. Because everyone will be moaning if we finish late. So unless we start now,
Sorry.
that's okay. Well done. 1, 2, 3, 4, 5, 6, 7, 8. We need 3 more. 2. Yep, we're fine. So warm welcome to our office of the Auditor General. It's good to have you here, and you can see we're taking this pretty seriously, as we should. So, Catherine, I don't know if you wanted to make any introductory remarks, or should we just crack into it?
We'll just crack into it, but I do want to welcome Sarah Lineman, who will be familiar to a lot of elected members here, who deals with Auckland Council local government matters, and Jonathan Keats, who's a long-standing member of the office, who deals both in a legal context and in substantive matters across the office in the local government context as well. So hand over to the two of you.
Okay, good afternoon. Just to continue from what Catherine has said, my name's Sarah Lineman. I'm the Sector Manager for Auckland Council, so have been here on a number of occasions, and Jonathan is also in the local government team and is the Senior Solicitor at the office. We're here today because we understand the importance of the process that you're going into, and we want to make sure that we can make clear to you the support and guidance that our office is able to offer. And we have a shared interest, obviously, in decision making being made on a good foundation, strong basis. So Jonathan is going to take you through some of our guidance material. Part of it has been covered already this afternoon, and we're happy to take questions as we go and at the end as well.
So acknowledging that we've sort of gone through quite a big chunk of the stuff already.
Yes, so there might be a bit of repetition, but I guess it's good to reinforce some of the messages that you've heard from Catherine. So I'm going to run through our guidance on managing conflicts of interest with a focus on financial interests, because that's where we have the statutory role under the Local Authorities Members' Interest Act. And the focus will be on just a reminder of what the rules are on the Act, but how the Act might help, and how the Act does have some mechanisms that might be able to assist to manage financial conflicts of interest if there are any that are significant and do need to be managed in the context of the unitary plan discussions. So basically our definition of conflicts of interest is where two different interests intersect, and where your duties as a member of the council could be in conflict or could be affected by some other interest or duty you have, whether that's a personal interest or whether it's a duty because you're part of another organisation such as a trust. And as Catherine pointed out, and is clear from our guidance, conflicts of interest are inevitable when people are in public office. They are often have a lot of interests in the community as well. They're not necessarily a problem, but they can cause problems if they are not carefully managed, and they can create legal risk to council decision making. So for local authority members, there are these two main aspects. Financial interests are regulated by statute by the Local Authorities Members' Interest Act, 1968. And non-financial interests are regulated by the common law rules about bias and procedural fairness. And these are the matters that Catherine referred to: predetermination and bias that can be perceived based on relationships. And why it matters in terms of why do councillors need to properly manage conflict of interest? That members of the public have very high expectations of good decision making made with integrity, impartiality and transparency and fairness. Poor management of conflicts creates reputational risks both for the council and for individuals. There could be a legal risk and associated cost if decisions are challenged through judicial review. And in terms of financial interests, under the Members' Interest Act, it's a criminal offence to take part in discussing and voting on a matter where you have a financial interest. So that is different and more serious than a non-financial conflict of interest in terms of a personal liability and criminal offence. So the Auditor General has a role under the Members' Interest Act and has had for a long time, of investigating and, if necessary, prosecuting potential breaches of the Act. And we can also consider applications for exemptions from the rules in the Act and declarations. So, as I said, there are some procedures in the Act that can help to manage conflicts of interest. We issued general guidance on the Act. Catherine has taken you through some of that. And generally, from time to time, we call for reform of the Act because in many respects it is very old and outdated. That hasn't been picked up as a priority for government yet. There hasn't really been a strong call from the local government sector for reform, but that would be something that we think the Act is very old, it's poorly worded in some aspects, and it is overdue for reform. On the other hand, it does have some useful things, and I think, as I explain how it might apply in this situation, there are still some good features in the Act. In terms of non-financial interests, we don't have the same statutory role, but as part of our mandate to do inquiries into how councils use their resources or to consider issues of probity, we do sometimes inquire into non-financial conflicts of interest. And our guidance does give some broad guidance in that area as well. In terms of the rules in the Act, there are two main aspects. The main one is the prohibition on discussing and voting on any matter where a member has a financial interest, and that is at a meeting of the council or of a committee of the council, unless that interest is in common with the public. So if a member does have a financial interest and discusses or votes on a matter in which they have that interest, it's a criminal offence and they could be prosecuted and lose their office, although that is very rare. There's also a transparency requirement, so if a member does have a financial interest, they are required to declare it at the meeting, and that declaration has to be minuted. The other main aspect I'll talk about is the exemptions that are available under the Act where a member does have a financial interest. So in terms of the general things to think about when a matter is coming up for discussion and voting, you need to focus on what is the matter that is going to be discussed. Is it, the Act applies to, if you have a financial interest, you need to think, what is the matter that has been discussed or voted on that I might have that interest in? And the rule applies not just to voting, but also to discussion. Then you work out whether you have a financial interest in that matter, and the test that we apply for financial interest is whether, if the matter is decided in a particular way, you would have a reasonable expectation of either a gain or a loss of money arising from that decision being made.
Is that personal gain of loss?
Personal, yeah.
Loss or
personal
gain.
Financial effect.
Okay, thank you.
Yeah. Positive or negative. You then need to think about, is the interest in the common?
In that respect, could you mention then Debbie Hewitt of the Hawkesbury Regional Council and the Rui Taniwha Dam, who did have a financial interest, but your office said she was allowed to vote?
Yeah. I'll cover that when we get to the declaration.
Okay.
Yeah. Which is, basically that's an example of how the Act can work in that situation. So then, you work out, is the interest in common with the public? Because if it is, then the prohibition doesn't apply. And then you think about, do any of the other exemptions in the Act apply, or could I apply for approval in advance of the vote to participate, notwithstanding that I have a financial interest? And that's the Councillor Hewitt situation, which I'll talk about in a bit. In terms of the decision that's been made, it's important to think about what sort of decision is it. So the Act is more likely to apply where the decision is a substantive one and less so if it's a procedural one. So a member is unlikely to have a financial interest in a decision to consult the public on a proposal, but if the decision is about the outcome of consultation and a proposal to do something, then the financial interest is more likely to arise. So I guess in the context of the unitary plan, it is going to be substantive matters, not procedural matters that you will be having to decide. So basically, yeah, it's very important to focus on the nature of the decisions that are being made and then think about, do I have a financial interest in any of those particular matters? The Act covers both direct and indirect financial interests. So a direct interest is one that would be held by the member personally, and it might be through, for example, through owning property. So a decision might have an impact on the value of that property. A member could also have indirect interests, and Catherine mentioned in response to a question that a member could have a financial interest through ownership or involvement in a company. And the Act has a series of rules that says if a member's interest in a company is over certain thresholds, such as a 10% shareholding or the managing director of the company, then they are deemed to have an interest in a matter if the company has a financial interest. An indirect interest can also arise if the member's spouse or partner has a direct financial interest, and then in that case the Act deems the member to share that financial interest. In terms of the interest in common with the public, so the prohibition against discussion and voting only applies if the interest is one that is not shared in common with the public. So to determine whether it's in common with the public, you need to work out, do other people have the same sort of interest that I have in this decision? And if so, is it of the same kind and size and extent? And how many of those people are there? An interest doesn't have to be shared with every single member of the public, but it has to be a decent size group for it to meet that in common with the public test. Catherine referred to some of the work that we did in the Environment Canterbury Members' Interest Inquiry, where we did make some comments about interest in the public, and there is some guidance there to help work out when the size of the group might be big enough to qualify for in public with the interest in common with the public. So basically, a rating decision, which is a broad rating policy decision, will be one that will affect a lot of people. A decision on a small targeted rate that just might affect a small number of people will be not necessarily in common with the public. And often people give the example of dog control decisions that might, dog licensing fees. Well, enough people own dogs for that to be in common with the public. But if it was something about a permit that only a small number of people have, then it's not in common with the public. Other examples, reasonably common examples of interest not in common with the public are a property developer's interest in planning matters and things like development contributions, because they are affected to a much greater degree than your ordinary residential homeowner. And as I said, if you're one of a small group affected by a targeted rate, that won't be in common with the public. There is a somewhat outdated exemption in the Act for district planning matters that we're not fully confident that this applies to the Auckland Unitary Plan. It's not, if you look at the wording, it was written in the days of the Town and Country Planning Act, and it was written in relation to the preparation, recommendation, approval or review of a district scheme under that Act. The wording has been updated to refer to a district plan under the RMA. So basically the policy of this is that if the council is considering adopting the district plan or reviewing the district plan, so making a significant decision that affects the whole plan, then the prohibition against discussion and voting doesn't apply. But if it is just deciding a matter that relates to a variation or a plan change, so it's part of the plan, or a resource consent, then the prohibition still applies. It's a bit unclear as how you would read this provision as related. It doesn't address a regional council or a unitary authority adopting a unitary plan. So whether this applies will come down to, it's hard to work out until we see what the plan looks like, whether it could be whether district plan parts could be separated and distinguished from the whole. So I guess general thought is it would be unsafe to rely on this exemption at this point. In terms of other exemption abilities in the Act, there's basically, the law is not concerned with de minimis or trifling matters, so if it's a very small financial interest, the member can apply to the Auditor General for an exemption that their interest is so insignificant or it's remote that they should be able to take part. And remote meaning several other events would need to happen before the interest might arise in the future. And insignificant is basically financially insignificant to that member given their financial situation. This is, it's not used all that often, this exemption, but it is available, and it does require the member to make, or the council on their behalf, to apply in writing before the decision has been made, and we would need to be very clear on what the decision, what the financial interest is, and what the decision is, and the member would need to make the case as to why their interest was so remote or insignificant that it wasn't going to influence their participation in that matter. The other one is more relevant to the unitary plan, I think, and this is where the Act may be able to help if there are some interests that need to be managed. So the Auditor General can grant a declaration enabling a member or members with a financial interest to participate in a particular matter on either of two grounds. One is that if the prohibition against discussion and voting were to apply, that would impede the local authority's business. The second is that it would basically be in the public interest that the rule not apply. So the procedure for either of those is a written application in advance by the member or the council on the member's behalf. So this would follow the process that Catherine has offered, where members work through what their interests are and how they might be managed. And we're happy to be, to be part of that process as necessary. We would need detailed information to understand what the financial interest is and what the nature of the decision is to be made, and how that decision might affect the member's financial interest. In terms of the two grounds, the business impeded ground, this has applied in the past where a significant number of councillors have a financial interest, and so basically a large number of councillors can't take part in discussion and voting on a significant matter, and only a small number of councillors can take part. So in that situation, we will co-opt you. How about that? In that situation, the rule could be seen to be unduly distorting the way the council could do business, because only, say, a small number of members could take part. And I think the example here was actually an Auckland example around owning shares in Auckland Airport, where a number of councillors own shares in the Auckland Airport. The council had a strategic decision to be made about its shareholding. It was considered, and I think we gave the declaration that it would be, the council's business would be impeded if they all couldn't take part in that decision. The other ground that is a bit more also potentially relevant is the public interest ground, and this is where we need to weigh the risk, weigh the benefit of the members with the financial interest participating against the risk that those financial interests could affect the decision or the outcome. So considerations here are whether the member has particular expertise that they bring to the table that would otherwise be lacking. There's a representation issue, whether the people that that member represents would be adequately represented if the member couldn't participate, and whether the matter is so important that it justifies the involvement of all of the members around the table, whether they have financial interests or not. And you may see that the unitary plan is of that nature. So just in terms of some examples of declarations we've given under this ground, one that was some time ago, a councillor on the Far North District Council was a very keen advocate for building a bridge across the Hokianga Harbour, which was an idea of some years ago. He owned land on one side of the harbour that could potentially benefit if the bridge was built. He had stood on an electoral platform of being a very strong proponent for the bridge, and then when he got onto the council, he realised that he couldn't actually deliver on that platform because he had a financial interest in the proposed bridge. But we said in that situation, when he applied for a declaration, that we were comfortable giving a declaration largely because of that representation issue, that he had strongly stood on that platform, and we thought it was important that he could give voice to the people who had elected him. The other one that Councillor Casey mentioned was Councillor Hewitt. That's a more recent one in the Hawke's Bay, member of the Hawke's Bay Regional Council, in the context of the council's decision making about the Ruataniwha water scheme. In that case, the council is going through the final stages as to whether to put its $80 million investment into the scheme, and there are a series of final conditions to be met that they are now voting on. The councillor owns some land that is in one of the areas that is potentially going to be irrigated by the scheme. It's not a large bit of land, and we decided that the councillor did have a financial interest in the decision to invest in the water scheme, but it was unclear how big that financial interest was. And the councillor made the case, and the council on her behalf, that this matter was so significant for the whole Hawke's Bay region that all elected members should be able to take part, and we accepted that, so we gave a declaration in that case. So in terms of declarations and exemptions, these ways that the Act, the strict rules in the Act can be made to work, we are happy to receive applications and work with members and council staff on these. It's certainly helpful if timing is tight, that we get as much information in advance as possible. And just to recap, our guidance publications are available. There's a series of frequently asked questions in Part 6 of the guidance that is quite helpful around associations with other bodies and, non-financial conflicts of interest as well. Thank you.
Thank you. Right, I've got Councillor Casey.
Right back near the beginning, you talked about conflict of interest having to be declared at committees and council meetings. My question relates to workshops, because we will be having at least one behind closed doors workshop, be it high level or otherwise.
We're not workshopping any of this.
I've got one in my diary for next week.
Oh, that's just...
And I think we discussed it earlier, and it was high level, not to worry about it.
That's just the discussion.
So just and the question stands, so we'll get an answer
we're
on
not
that. But
having
just
any
to be
workshops on the
clear,
unitary
so
plan?
we're not running workshops on that.
Cool.
We're having a briefing, which is what everyone's asked for. We're having a content briefing on Wednesday.
No, the briefing, that's what I mean. Is the briefing a workshop? Is the briefing something we have to declare interests at? Or can we go in there and say whatever we like about whatever we like, because it's not a committee or a full meeting?
Well, I
was asking the Auditor General's office, because it was he who said it.
I've just got lots of yeses around the room, and that's why I'm just going, no, let's just actually hear the advice.
It's a bit of a grey area, actually, around workshops. I think the wording of the Act is that a member shall not vote on or take part in discussion of any matter before the governing body or before the committee in which he or she has a financial interest. So the question, I guess, is whether the workshop is a meeting of the governing body or of a committee, or whether it's something else again. And I think we've taken the view, and I'm not sure whether this is in our guidance, that good practice would require that conflicts be declared at any meeting which involves the governing body or a committee, whether it's a formal council meeting or not.
Thank you.
Okay. I've got councillor Cooper and then councillor Stewart.
Thank you, Madam Chair. I think just going back to the local alcohol plan, and it wasn't clear for me around, and I had a conflict, and I wasn't sure if I was to come to workshop or not. I came to a workshop, and the next thing I know, I got an email from our lawyers requested by one of the councillors, and they were going to announce it all in public in front of everybody, so I just didn't come to the meeting. So it was pretty clear that it was considered by our lawyers that a workshop was the same as a duly constituted meeting in that regard. So I didn't go to any more of those at all, a workshop or anything. So for me, that answers that question. Unless it's been managed somehow or it's been declared, and you can't. I don't know. It's just, yeah. I came down on high from that one. Very heavy-handed, out of the blue one for me.
Yes, because I think a workshop, a workshop is obviously still a meeting, isn't it? But it's certain rules don't apply as long as no decisions or resolutions are made.
Well, that wasn't the case in this one. I wasn't allowed to come even to a workshop and just sit there. So, and the same for Councillor Close.
So maybe that's one of those, as we meet on an individual basis and get absolute clarity on the conflicts, the genuine conflicts, and how to manage them. I think it'll be also good just to be clear,
before Catherine was the boss,
what the issue is at a briefing, which I wouldn't imagine there's a huge amount of opportunity for great debate and discussion. Everything else after that are meetings. Councillor Stewart.
Thank you. I actually made a personal submission about the sites and places of value for Mana Whenua, and that was the only part of the unitary plan that I made a submission. But I don't really believe that I haven't got a personal interest other than it's really very in common with the public. I don't really believe I have a real personal issue there, and I know that the Maori Statutory Board put in, I believe...
put no personal submission in?
No, the Maori Statutory Board, whether it was personal or not, they actually put in a submission to the unitary plan, and yet some of those members or members of the Maori Statutory Board actually sat on the unitary plan.
So, Councillor, I think we could all now go around the table and talk about our different conflicts. My advice is very clearly your conflicts and the issues that arise for you, you need to meet with our staff and go through those with our lawyers, as will each member of this, as will the Independent Māori Statutory Board. It's not for us to point out other people's conflicts, perceived or real, and we need to deal with our own, and I'm very clear about that. But you do need to sit with our legal team and go through anything that may be a possible conflict of interest, including people who've put in submissions. So, our staff and our legal team are there to advise fully on this, and I think it would be somewhat derelict in our duty for us not to fully participate in that, as well as fill out our declarations of interest, which are then available. So my advice is to do that. Councillor Casey, did you?
Yeah, no, I just want to be clear, because at workshops we have never asked participants to declare interest. Are you saying that that's what should happen? At workshops, briefings, anything that's not a formal meeting that's minuted. So you're saying that we should have that declaration of interest at workshops and briefings as well?
I would, yeah, well, in terms of transparency, it's always best, the requirement is if you have a financial conflict of interest, you need to declare that at a meeting. So it comes down to, is a workshop a meeting? And I would say it is a meeting, even if it's not a formal, a workshop is a type of meeting, so yes.
And does it only relate to financial conflicts of interest? You said the word financial, but I would have thought any conflict of interest should be declared at such a time.
Yeah, non-financial as well. The Act, Members' Interest Act, requires financial interest to be declared, but good practice would require non-financial as well.
Rule of thumb, just if we do feel that there's any interest, is to declare it to your colleagues. Bottom line, it's not a fault, it's not a negative, it simply exists and needs to be named, and then we move on. And then, if need be, stand aside.
Unrecorded?
The Members' Interest Act requires a declaration to be recorded in the minutes. So if there are no minutes, that's going to be a problem.
So can I just seek the advice of the Auditor General's office on that? Because if we're asking people to declare and there is a declaration, then it needs to be recorded.
Councillor Casey, can we, I don't want to put our audit office on the spot, and this is a side issue that's not actually related to the topic in hand. Yeah, but hang on. This is not kind of free-for-all with the audit office. This is us perhaps saying to Marguerite or Phil Wilson or our democracy staff, can you follow up the issue of the right way for us to address this at workshops? I don't think we could do it on the hoof now.
No hoofing.
Okay. Any other questions? Member Tyke.
Kia ora, Madam Chair. Tēnā koe. This might sound bizarre, but I think I need to ask it. Council has made submissions and given evidence on the plan endorsed by the councillors. Is that a conflict?
No. Council has a specific role under the legislation, is required to participate and provide evidence to the panel, which is what it's done.
Thank you.
Same with IMSB.
Okay. Any other questions for our audit team? Councillor Fletcher.
Thank you, Madam Chair. I was going to leave this to the end, but I want to pose to you, I mean, what we are all doing is trying to work our way through this quietly, respectfully, and within the complexities of outdated legislation. I always joke each year that we set an annual plan that we all have conflict because our rates will go up or down, but that's just the reality of the situation. My question relates to the process from here on in, because it's really important to me that there is complete confidence and there can be no misunderstanding. I took some advice in and around the terms of reference on the Auckland Development Committee, and technically the work of the Auckland Development Committee as regards the unitary plan is complete as soon as the IHP report back. And the very difficulties that Kathy's sort of experiencing as she's trying to work out what is a briefing and what is a workshop and what is this and what is that, I think are going to become compounded if we have these additional layers. I would be interested as to whether or not the Auditor General has considered the matter of where this should be reported back, because the advice that I've had is that the work of this committee will be complete on the report back of the IHP, and everything that flows on from that needs to be very clear, unfettered. We don't want any complications, so I just appreciate your advice on that.
I guess my advice would be that you should seek advice from council officers about the best legal process and make sure that you're complying with that process, but it's not something that we could advise you on.
Thank you.
Okay. So we can clarify that, Councillor. Any other questions?
Goes to the question.
No? Shall we move on? Thank you very much for that. Certainly very, very clear, and no two ways about it. We need to watch ourselves every step of the way on this one. Thank you. So I think our final part of the presentation is John and Dan.
Thank you, Madam Chair. It's a very short presentation from me this afternoon. So this one is just on what to expect when we receive the recommendations from the independent hearings panel. So one slide essentially, plus we also have a timeline diagram that's an updated version of one that you may have seen before. It's emailed to you several weeks ago, so this is just the latest version with some new dates added. So what will we receive from the panel? So the panel has advised that the recommendations will be in two parts. Part one will be a series of reports, and there will be an overview report and approximately 60 topic reports aligning with the 60 or so, or generally aligning with the 60 or so hearings that the panel held over 20 months of hearings. So things like residential, that will be a topic. Rural, we would expect, would be a topic. Ecological areas may well be a topic. Those are the sorts of things we mean when we say topics. So each of those will have a report, but there's also an overarching report that explains, I guess, just some of the key findings of the panel and the way the panel has gone about its exercise of reviewing the submissions, considering the evidence and making its recommendations. So within each of these topic reports, there will be a summary of the key findings from the panel on that topic, and any recommended changes to the proposed unitary plan. And we expect that the reports will run to some roughly about 1,000 pages, so it's a pretty comprehensive, fairly detailed report that we expect in part one. Then part two is actually a revised proposed Auckland unitary plan. It's the text and the maps. The maps will not be in hard copy. They won't be in PDF format. They will be what we call a dynamic GIS viewer. So you're familiar with how the GIS viewer works. They're essentially, they've got their own GIS viewer, and they will be flipping that around so that the council can see its maps in a GIS viewer. So it's quite a new approach, but it's definitely the way that things have been heading in terms of maps and planning for quite some time. So those are the two parts. The text will be entirely clean, so it won't be a strike-through underlining approach. There could be many reasons for that, but I guess one of the key ones is once you start restructuring the unitary plan, you end up with so much strike-through and underlining that it becomes very confusing for a reader. So the benefit of showing what's been deleted with a strike-through and underlined for any new text vanishes. So it will be clean text, clean maps in a GIS viewer, and that's part two. Now just turning to the timeline that you've all got here, I'm wondering if maybe we can, it's probably too small to really see on the screen, but we'll pop it up anyway. So here we are, just a few days out from the 22nd of July. I've got a pointer there. So a few days out from 22nd of July, that's this Friday, I think roughly at about 3 o'clock, we expect the panel will deliver the recommendations to our Chief Executive. And then on the 27th of July, that's next Wednesday, there'll be a confidential briefing for the Auckland Development Committee at 9 a.m. And then at 12:30 p.m. on the 27th of July, and sorry, at that briefing, we will present an overview of what we as staff have identified in reading the recommendations as, I guess, the key changes in approach that the panel is recommending relative to the council's position at the hearings. So where the panel is recommending to do something quite different to what the council sought at the hearings, we'd certainly be looking at giving you a briefing on that so you're very clear on where the panel is headed in a different direction to the council. At that briefing, we'll focus on the 19 topics that the Auckland Development Committee has endorsed as its key area of focus in the past, but that does cover a very broad spectrum of topics in the unitary plan. Then at 12:30 on the Wednesday next week, we will publish on the council website all of the panel's recommendations, all of the 60 reports, plus the overview report, plus the clean text of the panel's recommended version of the unitary plan, and then we will be able to show to the public the GIS viewer that has all of the maps as recommended by the panel. At that point, those maps on the text have no legal standing. They are simply the recommendations from the independent hearings panel in terms of what the unitary plan should look like. If we move forward to the 3rd to the 5th of August, now originally that was the 3rd and the 4th of August, but we're aware that there is a committee meeting on the 4th of August, so we've added an additional date on the 5th for councillors to arrange an appointment with a planner or planners to find out further information about the panel's recommendations. Those sessions are not intended to be a discussion about the merit of the panel's recommendations or what officers might think about those recommendations. It's simply clarifying what the panel has recommended and assisting with finding any recommendations if councillors have yet to find the recommendations that they're after. We're very hopeful that your support staff will assist you during that period between the 27th of July and right through to the decision making later in August. So then we move forward to the committee dates between the 10th and the 12th and the 15th and 18th of August. Again, in this updated version, we've added in 2 extra days of committee meetings on the 10th, 10th, 11th and 12th. So originally, I think it was, it was originally the 12th, 15th, 16th, 17th and 18th. So 2 extra committee days have been added to just enable sufficient time for the Council to consider the panel's recommendations. There will be an officer's report accompanying the for that meeting, and in that report, which will go out in advance of the 10th of August, there will be officer recommendations to either accept panel recommendations on those various topics or potentially recommendations to reject panel recommendations. Where officers have recommended to accept a panel recommendation that differs from the council position, just by way of a bit of information, a reason for that may well be that through monitoring the panel's recommendations in its version of the proposed unitary plan over time, and potentially addressing the issues through a plan change, that may be a better approach than rejecting the recommendations. But until we see the recommendations, we really can't say any more than that. So that's the up till the 18th of August. And on the 19th of August, that is the statutory date that Catherine has mentioned, that we've mentioned many times before. The 20 working days from the 22nd of July finishes on the 19th of August, and the council must notify its decisions to accept or reject the panel's recommendations. And if rejecting any recommendation, the council must be very clear as to what the alternative provisions are. And just to recap again, the only way to extend that time period would be if the Minister for the Environment agrees, and the Minister can only agree to extend up to an additional 20 working days. And then on the 16th of September, that is the 20 working day date, and that is when the appeal period closes on all provisions apart from the designations, which have an extra 10 working days for parties to lodge appeals based on the parameters that Catherine outlined earlier. So that's it from me, Madam Chair.
Kia ora, Madam Chair. Tēnā John. Just a question, John. In the context of council adhering to the law under the Auckland Council Act in providing information to the Independent Māori Statutory Board, when will the board receive the recommendations that you say you're receiving at 3 o'clock today?
I'll answer that, John.
2 days.
Just to be clear, the Independent Hearings Panel will be delivering it not at 3 o'clock on Friday, it will be after 4 o'clock. They've told us that they won't be able to deliver it. In terms of the IMSB board will receive the information at the same time as the governing body receives the information, which is on the Wednesday.
Thank you for the answer.
Any other questions?
Easy, I thought easy.
I see.
Just on the back, questions and answers for councillors. There's another version of local board members' ability to speak out on the unitary plan here, which is different to that, which was in the two memos and what Catherine said earlier. Yeah, the question is, can local board members speak to the public about the unitary plan? Answer, local board members will not be making decisions about the unitary plan. Governing body does this. Therefore, local board members don't have the same legal constraints as councillors do. Before. Which means yes, you can.
Well, I believe that's consistent with the memorandum that went out.
Yeah. So we're saying yes, you can.
Yep.
The local board members can speak to the public and speak to the media about the unitary plan. Yes, they can.
Always have been able to, because they are not decision makers. The expectation, however, as we said, just to repeat what we said, the expectation is that the boards will respect the fact that we're now going into a decision-making phase, and hopefully will work with us on that one, but there's no guarantees and no legal obligations for them to do so.
Joe Biden, I didn't get invited.
Other questions? Councillor Brewer.
Thank you. John, it was put to us previously, and I think it's important to canvass again, that if we don't,
Bloody late. Well,
if we weren't to go through the process of rejecting a recommendation and the Section 32 analysis and business case and everything else that would entail, particularly around localised issues, it's been suggested that perhaps we could table a council plan, a future council plan change, that when the unitary plan became operative, a future administration could tackle at that point as a council plan change. And I just wondered, is that still on the table? What would it look like? Would it be footnoted in our minutes? And would it at all carry any, would it be binding for a future administration, or would it just be a kind of a footnote that councillors could go out to their communities and say, oh, well, I tried, and maybe the next council might be able to turn it into we'll at least review it as a plan change possibility?
it's a tricky one, that one, but it would probably be more likely to take the form of a recommendation to review how the provisions are operating with a view to possibly introducing a plan change if they're not working properly or not achieving a good outcome in the future. But any future committee with the delegated authority could make its own determination at a future date. So it would not be binding.
No. But it was something that, it's not my suggestion, it was a suggestion that came out of your department, that may be an eloquent way that councillors could put something on the table where if they could converse enough support from their council colleagues to at least indicate that the recommendation wasn't completely satisfactory and that a future administration may look at it as a plan change. Is that something that you're still able to work with, a process like that, or ideally not?
My view is the committee is free and able to make those sorts of resolutions. I guess we just have to be very careful that it's not seen as completely undermining the process that we've been through. That would be the only advice, or the main advice, that we would give.
Yeah, I also think that all this council could do is make a recommendation to the incoming council. It will be solely up to the incoming council whether or not they took up that recommendation to do a plan change. And I think if it did decide to do that, it would need to weigh up very carefully the reasons why it would be doing a plan change, because this process has gone through an independent hearings panel process where there's been a wide range of evidence submitted. So if a new council wanted to do a plan change to change a recommendation of the panel that this council adopted, they would need to think very carefully about the basis for that plan change, because it would be under very close scrutiny when it went out for public submission.
Thank you.
Now, is there another? Oh, Councillor Quacks.
Thank you, Madam Chair. In terms of this timeline, and I've asked the Chief Executive some questions around why the independent hearing panel, who will provide all the recommendations after 4 o'clock on Friday, and why it is being withheld from councillors until the 27th. I know that some councillors, some council officials and the Chief Executive will be privy to the recommendations, and that's very secret apparently. So given the fact that the unitary plan has been and the hearings have been a very open and transparent process all the way along, why is this 5-day period of absolute secrecy, why is that seen as a necessary provision of this timeline?
So I'll answer that. The process that this council has decided to follow with the unitary plan is that under the legislation you are not required to release the recommendations to the public until you notify your decision on the 19th of August. But the feedback that we've received from this committee is that you want to give the public as much information as soon as possible. And so you've asked for us to release the recommendations, put them up onto the website after you have been briefed on the recommendations. So one of the reasons why we have recommended that staff spend Saturday and Sunday going through the recommendations is so we can brief you properly before the public gets the recommendations, so that you are aware of the policy shifts and are not surprised by the public knowing almost immediately after you get it, because we will have no time to do that analysis if you ask us to release the recommendations on the Saturday. We can't do it on the Friday because we get it on a USB stick and we would have to upload it onto the website.
I'm not necessarily asking for it to be released to the public when it's available after the 4th, but it seems to me that it is reasonable to provide it to members of the governing body at that time.
So the other reasons that we are recommending a briefing on the Wednesday is it is a very large and complex documentation that we will be receiving. As John has talked about, we're expecting an overview report and 60 reports that go to over 1,000 pages, and that does not include the amended version that is recommended by the panel, which has no track changes. So there is going to be quite a lot of work needed to understand what are the changes in policy, flipping backwards and forwards between the notified version of the plan and this clean version. As decision makers, we feel that you need to have the benefit of us doing a lot of that legwork so that you are briefed and are ready for it when it is released to the public. The other issue that we are facing is that the panel has indicated at a public forum that it has restructured the plan. So it's not going to be pick up chapter 1 of the notified version and look at chapter 1 of the recommended version. They have actually restructured it. So it is going to be a very complex and technical process. We believe as decision makers that you need to be in the best position when it goes public to understand the implications, which is why we want to brief you on the Wednesday once a limited, and it is going to be a limited number of staff have done the legwork on those matters.
Yeah. Penny, I find, I'm not sure if I'm convinced by your argument, but I think anybody listening to this when it's being webcast would probably draw the conclusion that we're a bunch of pea-brains around here. We're not capable of thinking for ourselves, not capable of going through a document or a file without us first being directed by council officials. It may not be true, but that's certainly the impression that people out there may gain from the answer you just given.
I think, Madam Chair, if people think that, it's their prerogative to think what they think. What we're saying is you've got 1,000 pages plus of reports, you've got a brand new plan coming, which is a clean version, it isn't track changed. We want you to receive the recommendations of the independent hearings panel, supported by staff of the council who will give you some critical insight into what this plan looks like compared to the council's notified proposition in that plan. And quite frankly, to just give it to you bare and say go for it, really it doesn't see us doing the job that we should do for you. We can't hold the briefing before Wednesday because we've got local board chairs, the mayor, deputy mayor and some councillors in Dunedin. So Wednesday is a sensible time and place. We have our staff work over the weekend and Monday, and we give you the very best support we can to understand what's in front of you, and then it goes public. And you're in a position where you've got the period between the 27th of July and the 10th of August to personally prepare yourself for the decision-making process that you'll embark on the 10th of August.
Reply.
Okay, any other questions? Councillor Brewer.
Just on the staff's work to advise us on the policy changes, something I pushed in this meeting a few months ago, and were told there were no resources, and have since been watching $370,000 worth of advertising. I would actually like us to be advised, and I don't think it's unreasonable, at a macro level, on not just the policy changes or the zoning definition changes, but where we will be hit as constituent councillors will be at a territorial level. And I would like to think that we will have officers, and I've been told that there's no resource to do this, but that we would have an officer able to tell us at a macro level when it goes public, just some of the changes that have happened to our territories. And what I'm thinking of here is a phone call or an email that might say, you know, don't quote us on this, but roughly you've lost, you've got an extra 20% of mixed housing urban, this growth corridor has been changed out for this one, the 1944 overlay, Councillor Brewer, has been dropped, and so that affects, 41% of your area. There's 15% less single housing zone, and just kind of a macro ballpark kind of analysis like that we can go, oh, okay, is that good or bad or indifferent? Otherwise, if the officers don't give it, the community certainly will give their ballpark analysis of where the changes have been. So I want a kind of a beginner's guide off the bat from where each ward sat at a macro level in September 2013 and where each ward sits now as far as that colour coding map goes and the zoning changes geographically. And again, it doesn't have to be an in-depth absolute study, but it can be an indicative one to give councillors an idea as to the real change happening in the ward, because that's where the phone calls will come from, more so than about what changes to the national policy statements.
So the intention on the Wednesday is to give both an understanding of how to navigate the plan, but also the high-level policy shifts. Included in that will be a high-level overview of the key zoning changes around the region. And in addition to that, we have a briefing of local boards on the
4th, I think it is.
The 4th of, sorry, John?
4th of August.
4th of August, where we will have done a bit more analysis, because that is actually quite a lot of work to do the detail that you're talking about, Councillor Brewer. And we will have available there further information that will also be provided to the ward councillors, so that they also get that information, which will be more of that ward by ward analysis against the notified version of the plan against the recommendation. So we certainly understand that for many of you, an understanding of how the zoning or some of the overlays might have impacted your areas is really important. The other thing we have offered, and a number of you have taken up that opportunity, is that further information requests that you've sent in to us through your advisors, where you've indicated that you want further information on certain aspects, and we'll be working to make sure you get that information on those items, if not on the Wednesday, shortly after the Wednesday, so you're in a good position to know those kind of details.
And just finally, Madam Chair, officers are talking today about the committee making those decisions and having those discussions between the 10th and 18th of August. You yourself seem kind of open-minded as to whether it's the committee or the governing body. And I suppose this is, a huge delegation decision. And I just wonder if councillors are to make that delegation decision or whether it's been made for them, and if so, on what authority?
So, as I said previously, Councillor Brewer, we simply followed the process that we've followed before. If people need to double check and treble check the delegations, that can be done, but I don't think we can take that discussion too much further today.
The process before, Madam Chair, was a draft process, and we sat very informally a lot of the time with local board members, as you've asked for this time, and as Councillor Fletcher has indicated too, that if we're really wanting to have the dignity of the chamber here and solid decision making for everyone to take this at its utmost seriousness and for the public to see it being taken, and as Councillor Quacks has said, for us not to have a duplicated system, then surely it's not for a committee to sit between 10 and 18th of August. This is the biggest decision that we'll make in our political lives, one that biggest the region will make in 50 years. It's not one for a committee, it's one for a governing body. That's what the IHP's own website says, and that's what the public expects. So I'd like to think that that decision is pending. It hasn't been made without councillors' input.
Thank you, Councillor Brewer, and the final decision will always be made by the governing body.
When will that happen then? When will that happen,
Chair,
Madam Chair?
I was actually curious when you said that the Auckland Development Committee would do some work, and then the matter would be reported to the governing body. And I think that's just a duplication. I mean, as Councillor Brewer says, there isn't another more serious type of deliberation that we've had in the annals of this council than this unitary plan. And I just think it's a watering down of the process if it's going to be dealt with by two bodies of council and not by one. It just seems a duplication of our resources. So I just don't follow the thinking, and you haven't really convinced me on that matter at this stage. Thank you.
So we hadn't necessarily prepared for a long debate about this. I've got Councillor Quacks, Councillor Wood, Councillor Fletcher, I'm presuming, on this issue. And yes, Councillor Casey, we see you. So just acknowledging that it's nearly 4 o'clock and we're meant to finish at 4, it might be useful for us to bring this issue back for discussion. I hear the issues raised, pretty comfortable about the issues raised. Let's have this this discussion at a time when we actually have the people, and particularly have the mayor here, who's been guiding the decisions around this. So if it's on which committee, which council, how about we hold that? If there are any other issues people want to discuss, happy to discuss them. So Councillor Quacks, I'm presuming it's on the same.
Well, yeah, look, I direct people to check out the website from the independent hearing panel, the next step following the conclusion of the hearing, and it states that the council, and I'm assuming they put this in brackets to avoid any doubt, that the council, the governing body, will consider the panel's recommendations. And I think that they've got that in brackets in order to avoid any doubt about who will be making those decisions.
Indeed, and that's well understood, done well across that. Councillor Fletcher?
Thank you, Madam Chair. I think it's really important that there is a high level of trust between elected members and staff as we enter what will be a really important period in the shaping of Auckland. And what is coming through, and this is in no way disrespectful, but there has been perhaps the perception of a predetermination by staff as to the process and being managed. Therefore, I think it is important that there is clarity around that, and I would like to move that the report from staff be reported to the governing body of the Auckland Council.
Happy to second that.
Oh, that's fine. So that's, hang on, better just before I say that's fine. So just to make sure we're all talking about the same thing, Councillor Fletcher, so this is, you're moving that the report of today, that the meeting for today?
No, Madam
No,
Chair,
I'm
I'm accepting
Yeah.
the staff's requirement for time to absorb and to prepare for reporting to council, but I am suggesting, I'm moving, and it's seconded by Councillor Lee, that the briefing come to the governing body and all other meetings be those of the governing body.
Councillor, it's not appropriate for us to accept that recommendation at this time. There's no report nor background to that. I'd like us to deal with that. We can have that discussion at the governing body, and I know the Mayor will be very keen to have this discussion.
But
this is
Madam
not
Chair,
the
and I
time.
don't wish to be vexatious, I am basing that on the statute and all, on the reports, and also as someone who has participated in this discussion with the expectation that it would come to the governing body.
So, Councillor,
I don't believe
hear
that
you.
requires
No, I hear you really
a report.
clearly. Yeah,
That otherwise suggests that there is predetermination by staff in terms of managing this process.
Councillor, you're not hearing me. The final decisions will be made by the governing body. Let's be very clear about that. It's the process leading up to that that we just need to get clarity on. It is envisaged and has always been envisaged that the final decisions will be made by the governing body. No one is saying any different. We're becoming very, very circular here.
Madam
Chair.
Chair.
Councillor, we just need to take a deep breath and make sure that we've got all the facts in front of us. Because the final decision will be taken by the governing body, I'd very much like the Mayor to be present for this discussion, as the decision on process has been very much guided by his wishes.
So,
I
Madam
think
Chair,
that's
you're
not
ruling out of order my motion.
Well, I think it's superfluous, with the greatest of respect to Councillor Fletcher. The final decisions will be made by the governing body. No one is making any argument about that. It's the process prior to the decisions by the governing body that we just need to get clear on. Am I correct, Mr. Chief Executive? You might like to bring some light, shed some light on this.
I can confirm, Madam Chair, the staff have not predetermined whether it's the Auckland Development Committee or the governing body or a combination of those two bodies. We fully understand that the governing body makes the final decisions on accepting the IHP recommendations. It's as simple as that.
So, Madam Chair, does that not imply that the power does reside within this committee, which was delegated to have the work of the unitary plan until such time as the independent hearing panel reported back? I would have thought that the power does reside in this committee today to make such a recommendation.
No, Councillor, it would require that, you would need to show that this is an extraordinary item where there's urgency involved. There's no urgency involved in this. We have time to make this decision in a rational way with the full understanding of the legal implications and the wider implications of the way that we sit between the 10th and possibly the 18th. I don't see that there's a rush today. It doesn't necessitate an urgent decision, and I think we can take a deep breath and actually take some guidance on this and do it properly. We don't need to make decisions on the hoof. So, Councillor, I've got Councillor Wood, Councillor Lee, Councillor Casey, Councillor Quicks, Councillor Brewer. If it's in relation to this discussion, we'll have that later. Is it on any other issues? Councillor Darby? Was this you're on the list?
Just
Did you have
on the
another?
report, Chair, we have received some information today, so can I move the receipt of the report, the tabled documents and the presentations? Do I have a second?
Oh, no, we don't even need to.
So this
to do
does go
that.
to the minutes automatically without being received?
It does.
Okay, that's good
Fine.
then.
Thank you, Councillor Darby. Anyone on any separate issues? We will come back to the process discussion. Councillor Casey.
Right, on the 22nd of July, the golden rod comes into somebody's possession, and for 5 days it will be in somebody's possession. What I want to know is what security measures are being taken with regard to it, so that I don't open the Herald and find it all there.
Question.
So we have taken steps to really ensure that you won't open the Herald. So it's actually received by Stephen on Friday. and it will be locked away over the evening. And I will be the only one who can access it on the Saturday morning, where we then take it down to one floor of the council building, which has been, I suppose, secure as much as you can secure an open plan thing. We've only allowed a limited number of staff to come into the building over the weekend, which has concerned many people who have inputted into the unitary plan process, because as you're aware, it's been a cast of hundreds rather than tens, but we have limited it to a very small number compared to the number that's been involved. They've all had to sign confidentiality agreements. They will not be able to print off anything. They are not going to be able to email anything. We've set up the IT system, so while that they can read the recommendations on a screen, they cannot copy them, they can't print them, they can't email them. We're not going so far as to pat them down as they leave the building, but we are taking this really seriously, because we know how important it is that you are the first people to hear about the recommendations and brief them. So, and part of this is also about protecting staff. The smaller number that we have involved in that process, the more that we can make sure that they are also protected from any, perception that they might be providing information to the wrong parties.
So it's almost an absolute guarantee that we will get the information first.
Yeah. Thank you. Indeed, which would be fantastic if it works that way. Okay, that might be the end of the questions. Councillor Lee.
Yes, I think the meeting this afternoon and all the presentations and participants have underscored how important and legally sensitive this matter is, the unitary plan. And so I agree with the other councillors who believe that this must be dealt with by the Auckland Council in full session. I respectfully disagree with your comments about we've got plenty of time to make up our minds. I don't think so. Time is very short indeed, and that's all a part of the process. It's a very speeded up process. And so, Madam Chair, I disagree with you ruling Councillor Fletcher and my motion out of order, but I would ask you to give this serious consideration. The last thing this council needs, with the eyes of Auckland upon it, is a procedural row over whether a committee or the full governing body is the part of the council that deals with the unitary plan. It must be the governing body in full session and not the committee.
Thank you, Councillor Lee. We hear you. I think we've reached the end of the, if it's on this issue, Councillor Brewer? No,
Well, Madam Chair, I just wanted to,
Councillor
it
Brewer?
is on this
No,
issue.
Councillor
You
Brewer.
called out my name before as a speaker. So
And-
I'd like to move,
and
Madam Chair, because you asked us that we take a deep breath and we won't make a
councillors,
decision today.
and
Well, I move that decisions
very,
over the
very
delegations of the
clear.
unitary plan decision-making between the 10th and 18th of August be tabled and discussed at the
Councillor.
governing body on the 28th of July. That gives us breathing time as you've asked for, and that also gives us an opportunity as you've promised with the Mayor.
Madam Chair, I second
And so
that.
let's
Councillors, we're
kick that
doubling-
decision as a formal item
we're
on the
doubling
GB.
up.
No, we're not doubling up because you haven't tabled it, I'm tabling it. You've decided, but I'm tabling it for discussion. Because, Madam Chair, you say that the final decisions will of course be made by the governing body, just as we ratify the long-term plan in 15 seconds by the governing body, but the real discussion and the real decisions will be made
So
at committee is what you're proposing.
Deep breath again. We're just, what I was trying to say, and you didn't give me a chance to speak, the point I've been making before is that this can come to the governing body for the decision of the governing body with the appropriate legal advice and the wider issues well considered. We don't need to move that, it will happen. So
You've ruled it out of order.
Well, it's not out of order. We've made the decision that that's going to happen. There's no requirement. We have all the staff necessary in this room who've already agreed, and we
So
made
we will
that
decide the delegations
Made that-
on the 28th of July.
that quite clear about half an hour ago. Rest assured, that is exactly the process. I'd like to thank everyone for being present at the meeting.
Madam Chair, just before you do,
Yes.
just following up on, and to reinforce this point that's been made already. Again, reading from the Independent Unitary Hearings Panel.
Yeah, but councillor, we've all read this. We're all clear.
well,
You are
they put-
opening
well,
up.
I don't know
you're
if we can-
opening up the
well,
discussion
Madam Chair,
again, and I'm
not
seeing
sure.
people are getting ready to leave. Councillor, we've made the decision. I'm going to close the meeting. We all know where we've got to. Thank you, everyone, for attending, and we will see the further discussion at the governing body. Thank you.